What is intellectual properties? Intellectual properties refer to creation of mind, invention, literary and artistic work, design and symbol, name and image used in commerce. IP is protected in Law B. For example, patent, copyright, and trademark, which enable people to earn recognition or financial benefit from what they invent or create. By striking right balance between the interests of innovators and wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish.
Intellectual Properties Organizations. The Intellectual Property Corporation of Malaysia, which is MyIPO, is an agency under the purview of the Ministry of Domestic Trade, Cooperative and Consumerism responsible for the development and administration of intellectual property rights IPR system in Malaysia. MyIPO committed to carry out its mission to provide strong legal infrastructure and effective administration to enhance greater creativity and exploitation of intellectual property. Their main functions are to administer and enforce IP legislations, to provide services relating to IP protection, to encourage and organize cooperation programs at national and international levels, and to encourage and promote training and dissemination of information on IP. Their objectives are to establish a strong and effective administration, strengthening intellectual property laws, providing comprehensive and user-friendly information on intellectual property, promoting public awareness programs on the importance of intellectual property, and providing advisory services on intellectual property. The World Intellectual Property Organization is the global forum for intellectual property services, policy, information, and cooperation. Their mission is to lead the development of a balanced and effective international IP system that enables innovation and creativity for the benefit of all. Their main functions are to harmonize national intellectual property legislation and procedures, provide serving for international applications for industrial property rights, exchange intellectual property information, and facilitate the resolution of private intellectual property disputes. Their objectives are to promote the protection of intellectual property worldwide and ensure administrative cooperation among the intellectual property unions established by the treaties that WIPO administers.
What is patent? A patent is granting of a property right by a sovereign authority to an inventor. This grant provides the inventor exclusive rights to the patented process, design, or invention for a designated period in exchange for comprehensive disclosure of the invention. They are a form of incorporeal right. Next, we're looking at patent methods or laws in Malaysia. First of all, we're looking at equivalent patent search. This is useful for parties wanting to know the patent portfolio of a particular owner so that a consolidated action can be taken to attack validity of the patents or a part of due diligence exercise to be undertaken prior to assignment or license of patents. Next, prior art search or novelty search or patentability. These provide patents documents that disclose invention close to an identified technology. Infringement search or freedom to operate search. This identified subsisting patents that would bar the manufacture, use, or sale of a product or a product made according to process. This search is necessary before commencing manufacture or sale of a new product. Next, we're looking at validity search. This is used to attack the validity of a granted patent or to oppose a pending patent application. Also useful to determine the strength of a patent before taking an assignment or license of a patent. Patent file search. Used to determine whether the patent was prosecuted according to patent regulation. Often such searches are done to attack the validity of a granted patent or to oppose pending application. Competitors or third-party search. All patents applied for or granted to competitors or to any third party can be searched to learn their research strategies, identify key research staff, patent filing activities, etc. This gives a good indication of the technical areas a particular party is concentrating on.
What is copyright? It refers to the legal right of the owner of intellectual property. In simple terms, copyright is the right to copy. Copyright law gives creators of original material the exclusive right to further use and duplicate that material for a given amount of time, at which point the copyrighted item becomes public domain. What is trademark? A trademark is a way for a business to help people to identify the products that the business makes from products made by another business. A trademark can be a name, word, phrase, symbol, logo, design, or picture. For example, Coca-Cola and Pepsi are trademark names for a cola soft drinks. There are a few differences between trademark and copyright. Trademark serves for the brands with a purpose to distinguish their products or service from the competitors. For example, logos and slogans. Copyright is commonly served for the authors to protect the original creative or intellectual work, such as music and art. The time limit is also different for both. A copyright has a range of 70 to 170 years of time limit, but a trademark is indefinite.
What is a trade secret? A trade secret is a formula, pattern, physical device, idea, process, or compilation of information which is not generally known or reasonably ascertainable by which a business can obtain an economic advantage over competitors or customers. Example of potential trade secrets: a formula for a sport drinks, several methods used by professional posters and recipes, a new invention for which a patent application has not yet been filed, marketing strategies, manufacturing techniques, and computer algorithms. Ways to protect trade secret: restful access to the information, lock it away in a secure place such as bank vault. Limit the number of people who know the information. Have the people who know the trade secret agree in writing not to disclose the information or sign non-disclosure agreements. Mark any written material pertaining to the trade secret as proprietary. Advantages of trade secret protection: unlimited duration. Trade secret could potentially last longer than patent, 20 years, and copyrights. Your protection is theoretically worldwide. No application required, no registration costs, no public disclosure or registration with government agency, and effective immediately. These are famous trade secrets. First, KFC chicken recipe. Second, formula for Coca-Cola. And third, formula for Monster energy drinks.
Hi everyone, now I will present about the industrial design. What is industrial design? Industrial design is a process of design applied to products that to be manufactured through techniques of mass production. It means that we will create a product and produce it in large quantity. Industrial design is needed in our daily life. It used to improve the function, value, and aesthetic of the products. For example, iPods, cars, guitars, and even phones. These things are normally used in our life. We drive car to work. We use phones to chat, to communicate with others, and we also use phone to listen music. Now, we can see the evolution of the cell phone. Industrial design have give a lot of convenience to us. Industrial designers have improved the function or even the size of the cell phone. From the first cell phone to the last cell phone, we can see that the size has become smaller and we can use it in touchscreen. Let us see the common process of industrial design. First, industrial designer will research the information such as the material of product used. Next, they will start to sketch their product. They will make sure the exterior design can attract customers to consume. After sketching, they will do a comparative product research. They will compare the difference and similar of product with other companies. It is to make sure the product produced is better. Then, they will start the model making and prototyping. Prototyping is an experimental process like a sample of product before go through mass production. The next process after model making and prototyping is testing. Industrial designer will test and make sure the product can be functioned. Mass production and apply intellectual properties right will done after when the product can be produced. After the product are decided to produce, industrial designer will register the patent. Industrial design right is different with other intellectual properties right. It is because an industrial design is constituted by the appearance of a product, which must not necessarily be distinctive. Besides, the purpose of registering a patent and related requirements is to create a new product or process as a new invention.